You have 10 minutes, Mr. Drabble.
But I won't need them, as I'm going to deal with this very, very rapidly. The issue is standard of review. It doesn't arise as sharply in our case as possibly in Byndloss. We've dealt with it in our printed case on our submissions at paragraphs 141 to 158 in the core volume at MS 6627. And there is one point of departure between our case and the Secretary of State's case. And the single thing I wish to do is identify that. And if the court goes to the Secretary of State's case at MS 6781, it's headed at the top of 6781, standard of review. And the court will recall that the Secretary of State's case earlier on says that issues 1 to 3 share many common themes, and indeed that is the case when one looks at paragraphs 100 through to 109 of his case, which deal with this issue, because it's to some extent dependent on the Decisa Rabivo and Khalifa line of cases, paragraph 108. We've dealt with those. The point of departure is that identified in paragraph 107, which says that in that regard, a key distinction for present purposes may be that the Connors-Pinnock line of cases are concerned with an area where the proceedings are question of the only remedy available to the tenant, whereas in the present context, judicial review is essentially an interim remedy in circumstances where the applicant will still have a full right of appeal following removal. That's true if you're dealing about permanent removal, but not true if you're dealing with temporary removal pending appeal. It's decided once and for all by the certificate. It's an important Article 8 issue. It can lead to removal for a substantial period of time, although it's temporary. And the simple submission I make now, reserve the right of reply, but the simple submission I make now is that the point of departure identified in paragraph 107 doesn't work, because it doesn't lead to any right of review of the temporary removal pending appeal. And that may in itself, although properly described as temporary, be important. Let's not use the word like substantial, just important will do for present purposes. That's the submission. It may be that Mr. Fordham has some other submissions on this aspect of the case, but that's what I wish to say this afternoon anyway.
Thank you very much, Mr. Drabble. Mr. Marcus? Mr. Marcus, do you follow? Mr. Gill.
My lady, thank you. My lady, I adopt the submissions that you've just heard from Mr. Drabble. The printed case is long and detailed, and I adopt that too, and without repetition. There may be some parts of it that, well, a number of parts of it that I take you to amplify certain or to reinforce certain parts. But my oral submissions, I'm going to concentrate on 5 headings. The first of those is the legal tests to be applied. I may need to touch on the guidance in relation to that, but the guidance comes later. The second is in relation to the procedural and substantive protections in relation to children. The third is on the role of the court, but that will be very brief. Fourthly will be the guidance. And fifthly, I'll need to go through the facts of the case in order to understand the decision-making process, in the context of which one then begins to see how the principles that we will have covered by then apply. As to the legal tests to be applied, these are referred to in summary form in our printed case, MS 6666, paragraph 2. You'll see I've left out for present purposes paragraph 1, which is the role of the court point, which I'll deal with perhaps briefly later. But in paragraph 2, on 2.2 on page 6666, we set out how it is that the court erred in misconstruing the tests under section 94B. I won't be going through all of these points in great detail. For instance, the first point in the middle, 2A on that page, is amply set out in the written submissions. And to some extent, the court did, in fact, adopt that point. More particularly, however, in dealing with what is at 2B on 6666, we say that the court erred in failing to hold that, given the structure of the Principal Act for our purposes, the Nationality, Immigration and Asylum Act 2002, and given the aim or purpose of Section 94B as derived from that scheme, the public interest in deporting prior to the exercise of an in-country right of appeal is limited, generally speaking, to cases where there is a serious and unmanageable risk to the public in the period pending appeal. There is a very material distinction, therefore, between in the situation that arose in the Hesham Ali type scenario, where you're actually dealing with the full substantive appeal, Section 32 appeal, and this situation that we are dealing with under Section 94B, where the decision-making process is premised on the assumption that the person may well win will win the appeal in due course. The guidance actually directs decision makers to proceed on the basis that that appeal will be won. You'll see that in the guidance in due course.
Mr. Gill, I was wondering whether the appellant, who posed a serious and unmanageable risk to the public in the period pending appeal, would have a clearly unfounded appeal, and so it wouldn't reach the Section 94B decision.
Well, the problem is that we're dealing with a situation where there is no Section 94 certificate, the clearly unfounded certificate. Your Lordship puts to me, well, therefore, that may imply that it's something slightly less than serious and unmanageable risk. Well, I could live with that, my Lord. It may be that it needn't be quite as high as that, but certainly it has to be something significantly high, allowing for the fact that he may well win his appeal. The ministerial aims behind the enactment, we say, are not legitimate or rationally connected, but even if you were to decide those points against me, and I recognize that courts often do, on the legitimacy and rational connection point, and they tend to look at it all in the context of proportionality. I recognize that. Nevertheless, there is a point here which is worth considering. And without turning up too many authorities and materials, can I just try to approach it in this way? At paragraph 103 on 6698, we've set out some of the reasoning behind this line of argument. But rather than reading it out, let me try and emphasize a few points here. What we say is that the statutory scheme, the aims are said to be to prevent delay, to speed up the removal of the appeals process, and to avoid it being clogged up. Now, all that is set out in the Kiarie case at paragraphs 13 to 22, and that is at MS, if I can, sorry. 6590, and you'll see that what Mr. Drabble and Mr. Marcus have done is set out a number of statements. We'll see how these aims link up to the changes made by the 2016 Act, but essentially it is, as summarized in paragraph 22, to prevent delay in and speed up the process of appeals and to prevent the abuse of appeals. And we say, whilst you can have those aims generally speaking, those can't really be the aims behind Section 94B, because what Section 94B is getting at in the context of the statutory scheme in which it is set is something else altogether. It is recognizing that there is already in existence a statutory scheme which provides for delay and abuse. When you look at, I'm not going to take time to go over the surrounding sections, but there are, for instance, in Section 94, provisions for dealing with abusive claims, manifestly unfounded claims, for instance. Clearly unfounded claims. There are provisions in Section 96 for dealing with situations where somebody is raising points which they should have raised before, where they're simply delaying the appeal process. They've had the opportunity to do it before and so on. There are a number of examples set out in Section 96. So the statutory scheme already contemplates a system for dealing with abuse and delay of the appellate system. So what is it that Section 94B is getting at? Section 94B is not mandatory, of course, like Section 32. It is discretionary, as we know. And that is why we say that all that Section 94B is really doing is recognizing and giving a facility to the Secretary of State, a power to the Secretary of State to use in the occasional rare case where it is necessary to remove a person even pending appeal. Those cases are likely to be limited. I don't say there could never be such cases, but they're likely to be limited. They're likely to be even less limited. They're likely to be even more limited and rare in circumstances where there are children involved. In fact, it's difficult to conceive of a situation in which the Secretary of State could accept that the claim was arguable and not certified under Section 94, and yet in circumstances where there is a parental relationship with a child, a real one, not a completely, not one which doesn't really exist at all, but where the Secretary of State accepts that and then says, I consider it lawful to actually remove you pending the appeal. It is, unless there is something else which is significant and major, it is difficult to conceive of a circumstance in which in a children's case, Section 94B could be used. I don't say it could never be used. There may be circumstances with the continued presence of the person even for the period pending the hearing of the appeal, which may be about a year or so, is necessary. That is why we've put it in terms of serious unmanageable risks which can't be dealt with in some other way. It may be that the difference between such a case and a clearly unfounded case may be small, picking up the point my Lord Wilson made, and if there is to be a difference, I can live with that, but the difference may well be a very small one. And only in that way can one actually see the statutory purpose of the statute itself. Of course, what may actually be being done for other purposes may be something different, because the Secretary of State has other aims, bearing in mind the politically contentious nature of the subject that we're dealing with. But the articulated aims and the statutory aims, whether one looks at it in terms of the ministerially articulated aims or the aims to be derived from the statute, we say are not legitimate in the sense that I've described, I've put the argument, or rationally connected to the end aim of ensuring the speeding up the process. And even if they are, those points must feature heavily in the proportionality analysis in any event. In any event, we say that in each and every case, there has to be an individual assessment. It cannot be right to conclude, as the Secretary of State has done in her policies, in her guidance, and as the Court of Appeal appear to have accepted, it cannot be right to conclude that in the generality of cases, it will be appropriate, reasonable, rational, whatever phrase one wants to use, to have an appeal from abroad. That's what the Court of Appeal, I think it's paragraph 67 of their judgment or 7. But they say in the generality of cases that they can't see a difficulty with having appeals from abroad. And the whole thrust of the guidance and of the way in which the actual statutory power is actually unpacked and practiced is to drive a situation where almost everybody gets certified under Section 94B, and the expectation is that the appeals will be from abroad. So much so that by this process of testing legislation and then waiting to see how it's dealt with the courts, and then getting a bit impatient when it takes a bit too long, and then passing a new act, the 2016 Act, that says, well, we can't really wait any longer before we test it further. Let's just extend it to everybody, which is what they've now done in the 2016 Act. That's what appears to be the driving agenda. It is not an aim or a purpose which really meets with the statutory imperatives flowing from Section 6 of the Human Rights Act and from the Strasbourg case law, which I'll also deal with shortly. So far as as I say, I'm going to deal with headline points because I actually want to get stuck in the facts in some detail. So there's a lot more surrounding what I've said in the printed case. But just developing this theme a little bit further, and that is this. This idea of serious irreversible harm is still a live matter. Mr. Drabble put it in his submissions that this was so at an earlier part of the case before the Court of Appeal said, well, that's not the test. Well, the Court of Appeal certainly did say that that's not the test. But when one looks at the guidance, and I'll show it to you as later, the phrase still keeps being used. It still keeps being hammered. And it still appears to be something that appears to drive the thinking. And the reason for this, I think, stems from a problem that we've seen in other cases as to how guidance is painted, but also, and put forward to decision makers, but also it stems from a misreading of the Strasbourg case law. Can I very briefly show you a little extract from Hansard, which I think, I don't know who put it in, we didn't, but which one is it now? It should be in my bundles. Where am I? Which one? No, not those bundles. Was flagged, and it seems to have disappeared.
There's plenty, Hansard.
But well,
So on what basis are you asking us to look at it, Mr. Gill?
my lord, my lady, let me see if I can find the passage in a moment. It's at MS 5768. It's in fact, I was looking in the wrong place, Authorities, Volume 17, tab 192. And you'll see that MS 5768, the minister, Mr. Harper, says pretty well in the middle of the page on the left-hand side, the serious irreversible harm test is used by the European Court of Human Rights when it decides whether an individual deportation must be suspended pending conclusion of litigation, and in its rulings on what types of claims must be granted in an in-country appeal. In D'Souza, the Chamber confirmed that there must be a suspensive appeal in cases where there was arguably a threat to life or a risk of torture. We propose to keep that. In cases that raise issues about family or private life, the court made it clear that a suspensive appeal would not normally be required as long as removal would not cause serious irreversible harm. That's simply incorrect. But
I did ask you, Mr. Gill, on what basis are we looking at this?
My lady, I apologise.
I mean, normally we don't look at Hansard.
My lady, the only basis for it would be to see what was the aim which led to, and the thinking which led to the passing of the statutory provision.
But don't we have that in Mr. Drabble's case, in the paragraphs to which you referred? We see there what the government's aims were, and I understand your submission to be that they're not legitimate, and therefore when we're assessing the public interest, we have to put them to one side.
Well,
so what's the use of looking at this passage in Hansard?
my lord, my lady, the point that I was seeking to build was simply this, not by trying to understand the decision maker's thinking.
But we know that at certain stages there was a view which seemed to put all the emphasis on that particular paragraph, but that's been abandoned since the Court of Appeal, so we've moved on in any event.
Well, I don't know whether it's been abandoned or
It
not.
has been abandoned, I think, is Mr. Gill's
Well,
point.
as being the sole ground, it clearly has been abandoned. How it feeds into the Article 6 consideration, I mean the Section 6 consideration, was another.
Well, let me try to deal with it another way. It appears that the defendant is proceeding, we say, and I think we said this even without reference to Hansard, somebody put that in, so I drew your attention to it. But even without that, we have put our case on the basis that the other side have misunderstood D'Souza Ribeiro, and we've set that out in our printed case as to why we say they misunderstood it. And there are 2 points basically to be made in relation to it, and we've looked at the case, and it's in volume 16 of the authorities, there are 2 points to be made about it. One is that it does not use the phrase serious irreversible harm. And secondly, it, volume 16, tab 179, the relevant paragraph was at
This is set out at paragraph 96.
paragraph 82 and 83, MS 5247. And what paragraph 83 is doing is saying that whilst it is not imperative in order for a remedy to be effective that it should have automatic effect. Now that language does appear to suggest that in fact it may well be the norm, but it's not absolutely imperative in all cases. The Secretary of State's reading, hence their emphasis on the phrase serious irreversible harm, appears to be that it's saying the opposite, and we say that's a misreading. And also, nowhere is the phrase serious irreversible harm used. What they talk about is harm which is of an irreversible nature. I'll say something, I hope, briefly about that.
But that's all in the context of suffering treatment contrary to Article 3, which you might think would be serious harm.
Yeah,
So,
yeah.
I mean, I think, aren't we just playing with words?
Well, I don't know. I think that it may well be that when the Secretary of State is using this phrase repeatedly all the time in the guidance, and you'll have to make of the guidance what you will, the impression that is created is that this phrase is a high threshold.
But it's, the phrase is in section
Yes.
94B3.
Yes, it's
So
a
we're stuck
statutory
with
phrase,
the statutory
hence it's in the
phrase.
guidance.
The question is to what extent that should be allowed to infect your consideration of section 6 under 94B2. And that's where I think is, you would say pretty clear, that the Court of Appeal said the Secretary of State in a sense got it wrong. And
Well-
the guidance has been revised. So
Yes,
you're
yes.
still entitled to say, well, it's still lurking under the surface somewhere.
Yes.
Which it shouldn't be. That's one point.
Perhaps let me not take too much time over that. It may become clearer once I show you the guidance.
The key point surely is that serious irreversible harm is one test, but there is another, compliance with Section 6 of the Human Rights Act.
Yes.
And this appeal is really about whether the Secretary of State is complying with the Human Rights Act, and you say he isn't.
That's right. That's right.
So I'm not sure how this will help us looking at this particular test of serious irreversible harm.
Well, I won't take any more time over that. So far as the Khalifa case is concerned, which is also in the same bundle, you'll have seen that there, and I'm not going to turn it up, but I'll just make a few comments about it. You'll have seen that the discussion in that case about suspensive remedies was in circumstances where the court had already found that there was a breach of Article 5.4, which is about access to courts. It had already found there were other types of breaches which they set out. And their comments on suspensive remedies in the context of Article 4, Protocol 4, which is to do with the prohibition against collective expulsion of aliens, were limited to the circumstances of the case in which it was said that there wasn't even an allegation that there would be any sort of risk of Article 3 or Article... indeed, there was no allegation of any breach of Article 8 at all. What they were saying was there was a breach of Article 3, there was a breach of Article 5, and there was a breach of Article 4 of Protocol 4. But what the claimants were not saying was there would be a breach of Article 3 on return to Tunisia, their arguments about breach of Article 3 were in relation to the conditions in which they were held.
Yes, yes.
So the comments that were made in relation to suspensive remedies are extremely limited and narrow, and they provide no basis for saying that as a general rule, the position under Article 8 is that a suspensive remedy is perfectly fine in the majority of cases. Far from it, it is the exception rather than the norm. Perhaps I need to say no more about the legal tests for present purposes than that. As to, in this context, procedural protections, if I can adopt what was said by Mr. Drabble on this, and then add the following cross-references. And I don't know whether you'll wish to see them. It may be worth looking at some of them. It's Volume 3 of the Appendix Volume 3, page 540, MS 7407. And you'll see that this is the second witness statement of my instructing solicitor. I hesitate to stand here and read out.
Oh, we've looked at this.
No, you looked at the third witness statement.
We looked at the third, didn't we? Yes.
The second and the third, I think Mr. Drabble took the third from volume 5, but in fact the third is in this volume 2, straight after this one, and this may be the more convenient place. But both the second and the third witness statements talk very compellingly about the difficulties that there are in out-of-country appeals.
Are you saying anything different to what Mr. Drabble told us about that?
I'm not saying anything different in terms of the substantive overall point, but a number of your lordships were asking about what are the practical difficulties.
I was asking more about how they could practically be overcome and how you could do that.
Well, I'll give you some further references on that, but in relation to this...
There's a very vivid description of what gets missed from a hearing if it's by video link.
Where's that?
Yeah.
Including the misbehaviour of the judge, I think.
Well, it's a very real point in many
I'm not saying
ways.
that's wrong. I'm saying it's a vivid description.
Yeah. And it's... but that's all there set out, and it goes on onto the following pages.
Well, it does provide some information about costs of video
Yes.
links in Jamaica.
Yeah.
It does.
Yes.
And you'll see how that continues further in paragraph 11 on 7410, and continuing further. But again, I invite your lordships, my lady, to look at this. There is also in the same volume at MS 7452 a statement from Joe Swaney of the Coram Children's Legal Centre.
Other pagination, please, Mr. Gill.
Volume 3, 586.
Thank you.
MS 7452. And again, this statement also talks, particularly from paragraphs 9 onwards, about the difficulties. It draws attention to the paragraph 11 on 7455 to the case of J.O. Nigeria, where Mr. Justice McCluskey, and this is referred to, and it's one of the cases that I may not have time to take you to, but I do invite you to read that case in due course, where Mr. Justice McCluskey does set out in great detail what the approach should be to Section 55 and how general and total is the failure of the Secretary of State to follow the Section 55 duty. The case of MK, which is also one of his cases, is in similar vein, and they're, I think, pretty well next to each other in the authorities.
Sorry, what's the reference to JO in the bundle?
JO in the authorities bundle is at volume 11, tab 131, and MK is at tab 132. But they are cross-referenced in our printed case.
Yes, thank you.
And those cases have been referred to in the Court of Appeal as well, and nobody's said they're wrong or anything like that. And there have been a number of decisions by Mr. Justice McCluskey who has expressed some concerns about the lip service that is paid to the best interests duty routinely. And that's sort of the point that Joe Swaney is making in this witness statement at 7454, paragraph 8, uniformly bad practice. And again, at Mr. Sharma's third witness statement, you saw parts of it earlier. It's in the same volume 3 at page 543, MS 7409 to 7411. Those are also worth looking at. Yet further witness statements appear in this bundle at internal page 779, MS 7644, and that is a statement from a person who was involved in such an appeal. Lord Toulson asked about, well, can a High Commission assist? Well, this tells you the sort of response you get from High Commissions and the failure of assistance. And there is also, in the same volume, internal 790, MS 7656, a statement from...
MS.
MS 7656.
Thank you.
A statement from Corita Thomas from the Anti-Trafficking and Labour Exploitation Unit, who also talks about the difficulties that she has had in terms of getting access to video link facilities and questions about payment and so on. Other references are given in our printed case, but I'm not going to go through them now. There is a real point to be made in this regard in relation to Skype facilities, in that these facilities are not secure. There are a lot of data protection issues, and I think that in some judicial contexts, the use of Skype, a private provider, has been greeted with some concern. I put it generally like that because I don't have the statement at my fingertips or in the bundle that I'm talking about, but there was something recently that Skype's privacy was capable of being compromised. And there were therefore concerns expressed about that. There are data protection issues as well in relation to all this, which is why tribunals are very concerned about making sure that there are security issues are all dealt with. It is, in practice, extraordinarily difficult to arrange for that via high commissions. I'm not saying it's absolutely impossible, but so rare that the tribunals are completely put off it, as you've seen from the comments of Mr. Justice McCluskey in the Mohebullah case that Mr. Drabble showed you earlier this morning. Further concerns about the difficulties that there are in this regard about paying for returns and the proportionality of taking such actions when it's going to give rise to all these sorts of difficulties especially in a context where there are children, are referred to in a case from Northern Ireland called REA, Authorities Volume 11, tab 134 at MS 3991, and again by Mr. Justice Collins in a case called Macastina, same volume 11, tab 135 at 3896. That was a case in which the challenge was put on the base to the EEA, to a provision, similar provision in the EEA regulations. The challenge was put on the basis that the provision was ultra vires, and he rejected that challenge. But what he said about proportionality is quite useful in his concerns about the use of the power. So those are just some further references which perhaps indicate why it is that that this sort of procedure from abroad simply is incapable of, in practice, of working. It is really theoretical and illusory to say that the tribunal can sort all this out. We have set out in our printed case at paragraph 146, but I won't go over it because I've only got an hour and a quarter to get through the rest. But in our printed case, we've set out there a lot of sub-paragraphs which explain the difficulties that there are in this regard. And it is simply constitutionally not proper for the Secretary of State to say, or for the Court of Appeal to say, that the Secretary of State can somehow avoid the duty that is upon the Secretary of State to ensure that Section 6 is complied with, by then really throwing the burden upon under-resourced tribunals, which the very same executive finds ways of not funding, so that judges are routinely having to go out into the corridor in order to call the case in themselves. Yes, they do that. Because the resources are simply not there. Rooms are left given over to other purposes. The whole purpose is appears to be at any rate, to shut down the appellate system. And it is impossible in those circumstances to say that a witness summons procedure, which is what the Court of Appeal said could possibly be used, can work. That is criticized in our submissions on 6713, and I just invite you to just consider the various points which are there set out. Those points there, bottom of MS 6713 of our printed case, paragraph 146L, internal page numbering 51. And that cross-refers to our paragraph 24, because one of the points there is the Court of Appeal said, well, we recognize there may not actually be, it may not be legally enforceable. They can issue a witness summons. It may not be legally enforceable, the Court of Appeal said, but it'll act as some sort of pressure upon the Secretary of State to do something about bringing the person back. And if the Secretary of State doesn't, the court could draw its inference. With respect, that's not really an appropriate form of reasoning for that sort of, for the tribunal to be put in that position. Moreover, the person remains subject to the deportation order anyway, which requires him to stay abroad.
Have you any experience of the Secretary of State ever suspending a deportation order to allow a deportee to come back into the UK to give evidence?
No.
So your position is it's purely hypothetical?
Yes.
Yes, thank you.
Yes.
Has the Secretary of State got power to suspend the deportation order?
Well, this is what we're sort of trying to unpick when I said that, bearing in mind there's this deportation order, and we cross-referred to our paragraph 24, which I'm afraid we just have to take time to read in due course, where we say the deportation order is there. The person can't come back in any way unless something else is done. How is that going to be done? We don't know. The Secretary of State hasn't put forward no system for the Secretary of State to say that I can use this power under Section 94B in circumstances where the Secretary of State has not put forward a convention-compliant system of guarantees and safeguards is simply unacceptable. It's simply unlawful. An application will have to be made to the entry clearance officer abroad to re-enter the United Kingdom. So if Mr. Byndloss goes to Jamaica, he'll have to apply to the entry clearance officer to say, I've got to come back in for my appeal. The tribunal has made this witness summons. The entry clearance officer will have to apply the rules, will have to apply the normal law, unless the Secretary of State goes about some form of temporary withdrawal of the deportation order. And I don't know how that's to occur in the statutory scheme. Yeah. The comparison with entry clearance appeals is also referred to in paragraph M. And again, I just commend those points to you. These are generally prescriptive tick box exercise type appeals. Not always, I agree, but they often don't raise human rights issues, and the statistics show that only a limited number raise human rights issues. And in any event, that's a wholly different scenario. An entry clearance scenario is a situation where a person is abroad and is trying to get in from abroad. They have no right even to be here. That's completely different to the situation of somebody who has indefinite leave to remain in this country, like Mr. Byndloss does, and who is to be removed. It might be worth, I should have drawn your attention to this, it might be worth looking at the concurring opinion of Judge Albuquerque and a judge who joined in with him in the De Souza Ribeiro case, where he sets out that even how even undocumented migrants have rights to procedural fairness, etc. And that chimes rather well with the approach that we have taken in our own common law about duties of fairness. It chimes rather well with the approach that we've taken with our law in terms of the statutory provisions of providing for rights of appeal. Remember, the statutory scheme starts off from the benchmark that there has to be a right of appeal. And these are provisions which derogate from that benchmark, and the power, therefore, has to be looked at with great care. And Judge Albuquerque explains, by reference to a large number of international materials outside of the European context, how the mood is more and more towards ensuring that such persons do have rights of access to procedure. What is happening in Europe, in the USA, is perhaps testament to the importance of what Judge Albuquerque is saying in those pages. But in any event, let me move on. Those paragraphs then are linked to this point, which is set out from paragraphs 120 to 130 about least intrusive measures. To some extent, I've dealt with that already, but what we say is that quite apart from the procedural protections that Mr. Drabble has dealt with, what you've got to try to do, if you're going to use the Section 94B power, is to take the most least intrusive approach possible. You have got to ask yourself, why is it that you actually need to remove the individual in the first place? What is it that drives that? Yes, there is a public interest in removing foreign criminals, but there is also a public interest in ensuring that they have a fair hearing. Section 6 remains in place. There is also a public interest in ensuring that the appellate system set out under the 2002 Act is respected, and that the power, and it is only a discretionary power in Section 94B, is only used to the extent that it does not undermine that. There are a number of other types of public interests also which are relevant, which are set out in our printed case under the previous heading at paragraphs 103 to 119. But let me leave the generalities there and move on to the positions in relation to children. In relation to children, the important point to bear in mind is that children are almost always the innocent victims of the actions of others in this sort of context. Yet, they may well be British citizens, as they are in this case. They may well be children who've been here for a very long period. And in any event, they're entitled to have their procedural rights protected. They also have independent procedural rights which need to be respected in this context. Formally, the appellant to an appeal will be the deportee, but that, as we've seen from a range of cases in the House of Lords in 2007, 2008, is only half the story, because the impact on other family members is of great importance. So the impact on children is of particular importance, particularly if we remember to make sure that we see them as individual actors with individual rights. Not only as individual actors with individual rights, but as persons whose best interests must be protected unless there is some countervailing consideration of some great force, which overrides that. The judgment in ZH Tanzania, tab 61 of the authorities. These references are set out in our printed case, and I know these are authorities that you know very well, so I don't take much time over it. When one approaches it in that sort of way, and then says, well, there are, even before we move on to substantive protections, there are procedural protection issues that arise in relation to the children, then all the points that we have set out in our printed case in some detail as to what needs to happen are all to make an appeal successful, are all points which the children can pray in aid. It's set out a great list of things as to this. Yes, it's at MS 6715, paragraph 150 of our printed case. All those sort of points are important. Under this heading of the best interests of children, we've started off at paragraph 147 with a point which is a small point, which it perhaps sets the scene for how it is that the children's interests effectively became reduced by the Court of Appeal. They barely dealt with them. And what they said at their paras 34 and 38 may have driven that result, and that's referred to at our para 147 of our printed case. The case law on Article 12 and on the right of the child to have the wishes and feelings ascertained, to have their interests heard, those points and the case law relating to it is also set out in some detail in our printed case, and the general comments of the UN Committee on the Rights of the Child are also referred to. Again, I'm not going to have time to deal with that, but all of that means that there was that there is in a children's context, especially onerous duty upon the Secretary of State to carry out inquiries. This is no different to the duty that there would be on any other type of public authority in any other non-immigration context. We have that in the Children Act 89 and Children Act 2004, Section 11, and so on. And what Section 55 of the 2009 Act was intended to do was to bring the immigration system into line with the way in which other authorities, public authorities, apply this. This is all dealt with in the statutory guidance, Every Child Matters, which again, I know the court will have seen on other occasions, and which is also in the authorities bundle and referred to in our printed case. Now, so what does this duty of inquiry require? It requires something proactive, yet the approach of the Secretary of State, and this is, I suppose, the big, broader point, the approach of the Secretary of State is to say, I'm not going to make the inquiries myself. I expect the potential deportee, the putative deportee, to put forward information. Now, this may be in circumstances where the person is in custody, where the person has limited access to assistance, where the person is not able to fully articulate all the interests of the children, and where there may be time constraints, bearing in mind that there are very significant delays in providing documentations to prisoners within the prison system. This case is an example. You will have seen from what I've set out here that the 3rd of June 2013 letter didn't actually reach Mr. Byndloss until sometime in August 2013, although he was supposed to reply within 20 days. All right, that didn't have a practical impact in this particular case because the deportation wasn't going to occur till later, but you can see how it might in another case. And if these sort of inquiry letters are sent out. Now, with such short time scales, and then no further inquiries are carried out by the Secretary of State. I'm going to pause a little bit in terms of the case law on inquiries, because that is set out in the printed case, and it's the sort of stuff that the court will be able to get to grips with itself, subject to one point that I'll come back to develop. And I want to turn to the particular facts of the case in order to see how the duty of inquiry was simply not complied with. In this regard, it is important to look at, maybe start from paragraph 8 of our printed case. Well, the facts start at paragraph 3, but if we continue, this takes some time to go through, and I'm only going to be able to go through it to some extent, but to recognize the unfairness, this has to be dealt with. And this is important because what happened in this case was that the Court of Appeal expedited the full hearing, there not having been a first instance hearing at all on the merits, substantive judicial review. They did it at the request of the Secretary of State. It had been expedited anyway, but the Secretary of State then wrote to say, well, the date, even with expedition, is not enough. We want it brought further forward, which is why the hearing took place in September 2015, permission having been granted shortly, I think, in June or July. And it led to a situation where the Secretary of State then came up with a new decision letter on the 3rd of September 2015. Let me roll the clock back a little bit. Now, what had happened, as we see in paragraph 8 of our printed case, is that there had been a letter written by Mr. Byndloss, which is in volume 3 at internal 600 at MS 7466. And what he had the letter that he's responding to is date stamped. It's in volume 5 of the appendix. Sorry. MS 8191 is the letter which was then 8191, yes, appendix 5, 8191, 21st of June 2013 letter. It's stamped.
Pagination, please, Mr. Gill.
Internal 1325.
Thank you.
And it's stamped on the 3rd of August 2013. I know that we've made an assumption, I think, in writing this paragraph 8 by saying that it's circa end of June. I think it must have been shortly after the 3rd of August, in fact. And he says in that letter at 600, volume 3, page 600, MS 7466, he says, I've got this letter from you, but I need to speak to a solicitor. He sets out his reasons for wanting to stay. It's to support my family and 8 kids and so on. And you see what he says. He's asserting and giving evidence of an existing family relationship. This is evidence. It may not be, the Secretary of State may say, well, it's only a letter. Yes, but it's still evidence. That point becomes important when we look at this later. What then happens is, and this is explained in the witness statements, that letter which it had attached to it of the 3rd of June, the June 2013 letter, had attached to it a questionnaire, which is in volume 5. The questionnaire asked for details of the children. He gave the details of the details of the children were given in the following way. What happened is that one of the ladies, and all three of his partners, visited him, as the prison records show. One of them took it to Mr. Sharma, my instructing solicitor, who then wrote a letter at volume 3, internal, page 485, MS number 7351, in which he says this letter has been passed to him. And he then hurriedly, giving, I think, limited pro bono advice for about 30 minutes or so, fills out the questionnaire in part, sets out a number of documents. And you see it on MS 7351. He lists a number of documents. Now, the documents are all over the place. Unfortunately, that's the way the bundle's been done. But in our paragraph 8 of our printed case, we've sought to list them in order so that you can follow through how the evidence developed and what the lack of inquiry was. And you will see in the top half of that page 6672, MS 6672, our paragraph 8b, the various letters that there were. Including a letter from three letters from two of the mothers, 2B, 5, and 6. when you read these letters, written in the language of ordinary people with limited means and so on, you can see that they are talking about a meaningful family life where children of more than one parent are actually interacting with children of others. That will just have to be gone through, I'm afraid. The evidence was there. Then what happens is that there were also chasing letters from Mr. Byndloss, to which he didn't get a reply, and you'll see that when you go through our printed case and follow the documents through. But going on to now this was sent 4th of October 2013. Nothing happens. Secretary of State doesn't make any inquiries that we know of, doesn't ask us to provide any further information. Chasing letters are sent. And you see one of those is in our 8C, paragraph 8C, B's handwritten letter dated 1st of July 2014. That's in volume 3, internal 596, MS 7462. And 7462 gives details of the mums, gives their mobile numbers, so they could have been contacted. Each of the mums could have been contacted to say, well, this is what this chap is saying. Do you actually have a relationship? Do your children actually have a relationship with this man? The details were all given. He explains
What's said is that these letters were written, as we know, from prisons, and so any relationship at that time with his children was going to be very superficial.
You'll see from the prison records the visits that there were.
Yes.
True, there are the limitations, but people can keep very active, apart from the physical presence of living together, very active lives even from prison, which you can't do from abroad.
What you're telling us, I think, is that this raft of evidence, for whatever weight it might have, was served in
July 2014.
I thought it was in 13,
Well,
October 13.
Well, yes, the solicitor's letter was 4th of October 2013.
That included a lot of documents.
Yeah.
And then the next salient event was October 2014, when the Secretary of State signed the deportation order.
Yes, the Secretary of State made no further inquiries that we're aware of.
Yeah.
And we're saying that here was this man who had sent this information through, one of the ladies had taken the letter to the solicitor, and then in July 2014, he himself had sent a letter saying, look, contact, basically, why is he giving the mobile numbers? But because he's asking for the contact to be made. There are two other letters he sent at that time in June and July 2014, in July, August 2014, chasing. Didn't get a response, and that's referred to in our printed case. And then you get the October deportation order. Then what happens is that on the 27th of October 2014, you have a pre-action protocol letter, and that is Appendix 5 at in Appendix 5 at MS internal 1188, MS 8050. There is a pre-action protocol letter. Now, the reason why it's set out here is you can see what was attached to it. And immediately after it, there are birth certificates at page 1200, internal, MS 8066.
I'm not sure 8050 is part of Mr. Giles'
8054, I apologize.
Here. Thank you.
8054. And at 8059, there are a number of birth certificates. At 8066, internal page 1200, there's a letter from a probation officer. By this stage, he's been moved to a different prison, which has made it more difficult for the various ladies and children to visit. And that has created a certain amount of difficulty. But he speaks of the first paragraph on page 1200 says, there is no ways partner and children can visit. Partner and children, evidence of a family life. It may not be a lot of evidence, but this is a probation officer speaking as to the existence of a family life. And then at 8067, you see prison records.
Excuse me, Advocate General. It would help us if we could listen to Mr. Gill without being distracted by your conversation with Ms. Giovanetti. Thank you.
And at 8067, there are prison records. And you'll see that all of the ladies and all of the children various times are visiting him. And then there are telephone records at internal 1216 MS 8082. And some other, and a handwritten letter also from one of the ladies at 8090. Now, etc., with other supportive letters. Now, this is not considered, so far as we're aware. What happens then is, I won't go over it because of time, but all of this, we say, should have led the Secretary of State, even before the 6th of October 2014, but certainly after the 6th of October 2014, 6th of October 2014 being the first certification letter, to conclude that a Section 94B certificate was not appropriate in his case. And the reason for that is this. The original guidance, version 1 of the guidance, which is in the appendix volume 4, internal 1052 MS 7916, you will see that the policy at that time was this. At MS 7919, from July 2014, when the Act came into force, to I think end of October? So to 17th of October 2014, this was the policy in operation. And on internal 1053 MS 7919, paragraph 3.3, for the initial test phase, and this was the initial test phase, certification should normally only be considered under Section 94B in the following circumstances only. The individual is over 18 and the individual does not have a parental relationship. See paragraph 6 of the immigration rules, which of course defines parental relationship extremely widely to even include adoptive relationships. So any questions about whether one of the children was in fact a biological child or not really are irrelevant. She is, but it doesn't matter. And then it says, it will be possible to certify cases involving children where there is no evidence that the foreign national offender has any parental relationship. The implication being that you should not certify where there is some evidence. Well, before the 6th of October decision, the first decision, which for your note is, I'm not going to take you to it, is in Appendix 3, page 406 MS 7272. As at that date, 6th of October 2014, there was evidence provided. Now, somebody could, if they wanted to be adversarial about it in a way which is inappropriate in a children's case, say, actually, there are holes in all this evidence. You haven't explained this. You haven't explained. I want to know more about this, what the relationship between these three ladies, whether you lived, who you lived with at what time, and so on. But they didn't carry out any inquiries at all. They could have contacted the probation service.
Mr. Gill, is it right for us to be looking at the first decision? The Court of Appeal said, well, it's ancient history. There was another one.
It is right for you to be looking at it for this reason. If it is the case that at that time on 6th of October 2014, in accordance with the policy that was then in existence, this person should have had a decision on 6th of October 2014, which was to say, we're making a decision to refuse to deport you, but we're not going to certify it. If he was he should have had a decision at that date saying, we are making a decision to deport you, but we are not making a decision under Section 94B. So he would then have had a right of appeal. That's what he has lost by the failure to give him that. That letter of the 6th of October 2014 is a decision on the Section 32 arguments, of course, but then it also has to deal with the question of certification under Section 90, or any type of certification that the Secretary wants to use. Secretary of State in this case said, well, one, I'm going to deport you under Section 32. I accept that you've got an arguable case in relation to that, but I'm going to actually certify your claim under Section 94B, so you have to appeal from abroad. And we say, had that decision been taken lawfully, in accordance with the then policy, there would not have been a Section 94B certificate. We would have had a right of appeal. And that's what we are entitled to, because by the Secretary of State's own unlawful failure, why should we be denied that? So the Court of Appeal said, well, things have moved on. They said, implicitly accepted, well, that may be right, but insofar as they dealt with it, they accepted that the letter was defective for other reasons, but the reason why they did not, maybe a little bit more clear rather than trying to rush. The reason why they didn't fully accept this point is because they held that the Secretary of State could reasonably, Wednesbury reasonableness, conclude that there was no genuine subsisting relationship between Byndloss and any of the children. For that reason, he didn't have the benefit of this policy. That was their reason. And we say that's not a child-sensitive approach. You can't deal with this sort of decision-making without, at the very least, having regard to the duty to make inquiries in relation to the child. And two, bearing in mind the obligations under Section 6 and the approach to judicial scrutiny, the court should have actually looked at the facts much more rigorously themselves than just stand back and say, well, on all this information that is set out in paragraphs 8b and 8c of our printed case, all that documentation up to, in other words, 6th of October 2014, did not, on that material, the Secretary of State could reasonably conclude that there was no relationship, genuine and subsisting relationship between Byndloss and children. We say that's just allowing the Secretary of State to get away with making no inquiries at all in relation to the children.
Now, you were just taking us through the sequence. Can I see if I got this straight? You went up to the pre-action protocol letter of the 27th of October 14. JR proceedings were issued a month later.
5th of November.
14. There was then some interlocutory hearings. Initially, permission was refused, but in June 15, Court of Appeal allowed the matter to continue and set a hearing date for September 15.
Well, no, they said they expedited, and the expedition was going to be in December, expedited
Right.
hearing. Secretary of State said, no, we want this dealt with much faster in the summer, they said this. And the Court of Appeal then, despite our opposition, listed a hearing in mid-September.
Okay, so a hearing got set in September, and then in September, the Secretary of State served her evidence, Mr. Welsh's undated statement.
Well, the Secretary of State did more than that. Let me take you through that material, which is in...
Well, I just want to get a very succinct
Yep.
summary of it. Don't need to go into all the details.
Yes. My Lord, what...
Mr. Sharma, in his responding third witness statement, says that his purpose is to reply to the witness statement of Mr. Kenneth Walsh, served on the 15th September. Doesn't appear to bear a date, but it was, one assumes, made by him then or thereabouts.
Well, let me just deal with this succinctly, as your Lordship asks. So we're in this position in the summer of 2015.
Yep.
We're expecting to go to a judicial review on the basis of a challenge to the 6th of October 2014
Right.
decision. The Secretary of State, on the 28th of August,
Yeah.
Appendix Part 5, Internal 1289, MS 8155, on the 28th of August, late Friday afternoon, before Bank Holiday weekend, says, after reviewing additional information received from your client, which we'd sent months and months ago,
Yes.
we are going to issue a supplementary decision letter,
Yeah.
and we anticipate sending this to you next week. When Mr. Sharma is next at work on the 1st of September, the following Tuesday, he says, well, hold on, we want to serve further evidence. That's the next page, 8157.
But this all predated your getting Mr. Welsh's statement.
Yes.
Yeah.
And we said, hold on, we want to file further evidence. They say, well, bearing in mind the hearing's coming up, we're going to make a new decision and serve you our evidence. Yes. And what they do in that is then, and this is the complete unfairness of this procedure, is they come up with a new decision drafted not by the by ordinary caseworkers, but by, I think, the Deputy Director, Mr. Welsh, and who makes a witness statement supporting that decision, which is said to be supplementary to the decision of 6th of October, without withdrawing the 6th of October decision.
Yeah.
And we say, well, this is completely unfair procedure. We're entitled to win on our challenge to the 6th of October 2014 decision. If you want to now make a new decision, and if the Court of Appeal are going to actually let you do that, we want the Court of Appeal to consider the unfairness in relation to the 3rd of September decision given to us on the 4th of September 2015, and look at the evidence that we would have put in had we been given the opportunity to deal with that beforehand.
Yeah, well, I think we have that point. And then what happened was Welsh puts in his statement that is the only evidence, is it not, from the Secretary of State. And then you, in response to that, served your solicitor's third witness statement and other evidence, and that was the material before the Court of Appeal.
That's right.
Right.
Including, in particular, the Independent Social Workers
Sure.
Report, which is of great importance in
Yes.
this case.
Now, that date of that was, is it August or September
18th
15?
of September.
18th
Now,
September.
This is Appendix 3, page
Yeah.
611, MS 7477, and all of it really...
Now, this, you're saying, was one of the documents which, if the Secretary of State had held her horses for a moment, she would have got.
Yeah.
In fact, she didn't serve the Welsh statement. You've in response, put the ISW report, which has obviously taken some time to prepare, to which you say there's been no rejoinder.
Yeah.
You were going to give us a page reference to the social workers report.
That is MS 7477, Appendix 3, Internal 611. There is a supplementary one that the children who've
Yes,
that produce a supplementary.
that's been produced by
That's right.
the second intervener.
Now, we say that if the case, the submission made to the Court of Appeal was either you stick to challenge, looking at 6th of October 2014 decision, in which case we win, even on the Court of Appeal's limited approach, without even looking at the children's issues, we would have won. If you're now going to allow them to try to defend the judicial review on the basis of a new decision altogether, then you have to examine the fairness of doing that and take into account our evidence and look at our challenge to it.
Well, you say the Secretary could have sought simply to defend the initial decision and fought the case on the initial decision and the evidence relating to it.
Yeah.
What she in fact decided to do was to issue a fresh decision, but not to give you time to put in further material to influence that decision, which meant that her second decision was unaffected by the material which you had in the pipeline and which you then served.
Yes.
Right.
My lord, my lady, the unfairness of this sort of process is actually dealt with now by the Court of Appeal in a case called Karupan, which again I'm not going to have time to take you through, but it's volume 10, volume 10, tab 117, and I'll give you the MS number.
This referred to in your case.
Yes, it is.
Anyway, one of your points, which I mean, you may not want to take more time on it, is that because of the, you say, unfair, scrambled way in which this was all dealt with at the last minute for the hearing in the Court of Appeal, the Court of Appeal should have said, we're not going to look at the second
That's right.
decision at all. We're simply going to look at the legality of the first decision. If the Secretary of State then wants to make a fresh decision, she can do so in an orderly way, taking account of all the evidence which is now before her.
Yeah.
We understand that point. But do you want to take up further time on that?
No.
So I just have the reference in your case to the authority you just referred to.
Karupan. Where's it in our case? Because I think this case in Karupan had just come out shortly before we did our written argument. It's paragraph 248 onwards, where we deal with the use of supplementary decision letters, which is what Karupan is all about.
But the page reference for the authority itself?
Page reference for the authorities.
MS 3542, volume 10, tab 117.
Sorry, tab
117.
for what volume?
Volume 10, tab 117, MS 3542.
Thank you.
Do you have the MS number for Mr. Welsh's witness statement? It's 76559. I'm grateful. It's in part 3. Thank you. Did he respond to all the evidence that was currently available to the Secretary of State?
No, you'll
then?
see when I go through the decision letter that actually there are complete holes in it, and there are assumptions made about lack of visits and so on, and I'll only be able to deal with some of it. Anyway.
When they change the policy, all the more reason.
The position. So, what we have done, just to be clear about this, is submit that information. The pre-action protocol letter on 27th October, we submitted further information going back to our paragraph 8 of our printed case, at 8D, we submitted Mr. Byndloss's witness statement 5th of November 2014, volume 3, internal 488, and the MS number to that is at 7354. We submitted all that plus attachments with the JR bundle. They did nothing at all to consider it until the 3rd of September, giving us the letter on the 4th of September. Now, that is not a child-sensitive approach. That is an adversarial approach, trying to treat this as if it were private parties to litigation. Had we known that they had concerns about that information, because you'll remember the word I read out from their letter of the 28th of August, we are reviewing. They didn't tell us that they were going to be carrying out a review. Had they told us at an earlier point in time that they were carrying out a review and their timescale for the review is such and such, we would have said, we want to produce the further information. Mr. Byndloss came out from immigration bail, and this is of some relevance, on the 15th of April 2015. So he was was then not permitted, because of the way the bail conditions work, to go and to live back with his wife. He had to live and has to live at the moment at a different address, which is the address of a friend, but you'll see from the further witness statements that there are in the bundles how the families all get together and how he makes life comfortable for all the children together, even with that situation. Now, going back a bit.
So why was he not allowed to go back to live with his wife?
There is a rule that they have. It seems to be sort of almost automatic, that when there is a drugs-related offence and there is some concern that that at that property the potato devotee may have kept drugs, even though that may not be the actual firm conclusion, rather than let the person go back to that address, bail authorities seem to require them to live at a different address. That's the reason. No other reason than that.
So it wasn't a court order that he shouldn't go back to the family home. It was a condition of his license?
A condition of his immigration bail. He was released.
His immigration bail, I see.
Yeah, because he finished his sentence.
Finished his sentence, yes.
Yeah, he finished his sentence in October 2014.
Yes.
And he had been in 2012 detained from the address that he was living with his wife. This is in his second witness statement. He then spent in 2012, November 2012, he spent about a month on remand before he was then released. But then he was released again to a different address, and this was to one of the ladies, whose name I won't mention, but one of his partners, and it's dealt with in the witness statement. So he was living in family homes, if I can put it that way, with children beforehand. Yet when you look at Mr. Welsh's 3rd of September letter, there's no appreciation of any of this, which you could easily have found out had he actually carried out some proper inquiries. And going to that letter is at volume 3, internal 421, MS 7287. It's quite a long letter. We have provided a critique of it in our printed case, but If I just make some points orally now, you'll see at the bottom of internal 423 MS 7289, the writer talks about the current address. As you currently reside at, well, that's the address to which he was bailed. You have provided no evidence you currently live with your wife and children. Well, if this decision maker had said, I'm going to make a new decision, can you provide me with up-to-date information? This JR is not going to be dealt with on the basis of the information provided before the 6th of October. We're going to make a new decision. Provide me with up-to-date information. Then we would have explained the reasons. Moreover, Mr. Welsh could, had he made proper inquiries, have checked with the probation officers as to what the situation was about the bail. Could have made a number of inquiries. Then he goes on to say, in the paragraph beginning on 7290 at top, it is noted that no evidence has been provided by the wife. It's true there was no letter at that stage from the wife. There was a witness statement in preparation and then filed within a few days of this 3rd of September 2015. But again, had it been said to us, no evidence has been filed on behalf of the wife herself to support your claim. We know you claim it, but what does she say? Well, Mr. Byndloss may have said, hold on, what do you mean? I gave you her telephone number. Why don't you contact her? And if you want me to do it, and you're carrying out a review, tell me and I'll provide the information. Nothing like that was done. Next paragraph. You wrote to the Home Office on 1st of July 2014, provided telephone contact details. So they then check some telephone records, but when you look at the telephone records themselves, and this is explained in Mr. Byndloss's second witness statement, they've only looked at some of them. There's a wealth of them attached to the pre-action protocol letter that I took you to earlier. They say in the middle of that paragraph, the only other call on that number in May 2014 was on such and such. Well, they're looking at May 2014. The records go beyond May 2014. Lack of inquiry. And then they say, you fail to demonstrate that you have caring responsibilities for your children and you care, that you share their care with their mother. Well, that's even on the information that was actually before the Secretary of State, before the 3rd of September. That information is simply not true. Because those letters that are referred to in our printed case, paragraphs 8B, 8C, and the pre-action protocol letter annexes, and the filed on 27th of October 2014, and the JR documents filed on 5th of November 2014, say otherwise. If the Secretary of State didn't think that information was enough in some way, the Secretary of State had to make some inquiries. And then it goes on to say, for all these reasons, it's not accepted you have a genuine subsisting relationship. They then go through a similar analysis in relation to the second lady's children. And I could make similar criticisms, but there is limited time, so I'll restrict myself to this. At the bottom of page 7291, they say, internal 425, in relation to question 4, you provided no evidence that prior to your incarceration or since being released, you have lived with the children on a daily basis. Well, that's simply not correct, because had they actually carried out inquiries with the probation officers or asked us, it would have been apparent that he was arrested from the address which he shared with his wife in November 2012. Then, as I said, for about a month, at the end of 2012, he was on remand. Then he was bailed, but to the second lady's address. So it's just a complete failure to actually look at the evidence. They don't even disclose to us 2 of the letters, chasing letters that Mr. Byndloss sent Mr. Byndloss doesn't have copies of them. He was writing them from prison. And then they apply the immigration rules, and they apply this unduly harsh test within the rules, which I'll see if I have time to deal with. But then they they say at the bottom of page 7293 that, well, in the middle of page 7293, they note that one of the ladies say that you have contact with your children practically every day. So it's not clear whether this was a reference to the position as it was at the time the letter was written while you were in prison, or the position as it was prior to your imprisonment. Now, if they're uncertain about it, it's simple to say, this is a children's issue, we need to be very careful here. Let's write a letter and ask for further information, or let's phone the mother up. Nothing done. At the bottom, it says, it is noted that no detail is given of frequency of contact with, and it's further noted that the third lady's evidence is that prior to your incarceration, you were living with her. Well, that's right, because he was bailed in December 2012 to her and caring for the child that's there named full time. It's clear the writer simply has not actually engaged with the factual background, and neither did the Court of Appeal. It's just too difficult. And yet they use that point to say, well, if you're living with the third lady and the child T, you can't have been with the second, but they don't understand how the family relationship works and the different times at which he was living there. And then when they get to the third lady and her child, top of page 430, MS 7296, they then say, well, we don't think you're really, in effect, engaged. And this is at the bottom of page 7296 and top of page 7297. And yet, you've seen what the evidence, and yet in the first decision letter, as is now conceded in the statement of facts and issues, they had accepted, implicitly accepted, that there was a genuine subsisting relationship with the child that is named at the top of that letter on page 7297. So this is a complete volte-face, from which there has been a volte-face again in the agreed statement of facts and issues, recognizing that this is wrong. This is set out in our printed case. Now, all of this, coupled with what we have said in our decision, in our printed case, about the inadequacies of the inquiries, has to be seen in the context of the duty to make inquiries that exists in relation to children. The Section 55 duties and Mr. Justice McCluskey's trenchant criticisms of their completely hopeless practice. Now, as to their practice, it is important to look at what their own guidance is and how they completely fail to follow it. This is in Authorities, Volume 2, tab 9 MS 538. And if we can, this was the, now when we made this point in the Court of Appeal below, both the Court of Appeal and the Secretary of State completely sidestepped it by saying none of this applies because the Secretary of State could reasonably have concluded on a evidence-free basis that there was no genuine or subsisting relationship with the children. But we say this was relevant not only to that question of whether the Secretary of State could reasonably have concluded, reached that conclusion, it was also relevant to this point about inquiries as a separate point. And the points here are important. You see that on page 2 of 32, page 5, MS 539, It says what the purpose is of this guidance. Second bullet point, core elements are the Home Office's legal duty to safeguard and promote the welfare of children. They set out a number of things that need to be done. Going to MS 545, page 8, second bullet point, safeguarding includes preventing impairment of children's health or development. Now that's fine. The UN Convention on the Rights of the Child talks about the right of children to develop in the most optimal conditions. I'm slightly paraphrasing, but that's what it comes to. And yet what they say is this, in the middle of that page, having set out what safeguarding means, they say, this does not override existing immigration enforcement functions. Consequently, the duty does not replace criminal casework directorate. Casework's duty to protect the public. Now, that's incorrect. That's contrary to ZH. That duty may override existing enforcement functions in some circumstances where it is in the best interest of the child to do so. It may not do, but they can't put it in this way without drawing attention to the approach in ZH, which they nowhere do. And this is what leads the thinking, both in the Secretary of State, and it has to be said in divisions in the Court of Appeal, to think that children's arguments are going to get you nowhere in these sort of cases. That's incorrect. Over the page at 547, it sets out some of the key partners that you should engage with. And it says in the middle, second paragraph, you must actively consider the needs of children, actively, if deportation is going to mean separating the family unit. For more information, etc., etc. If any file shows there are child dependents, you must consider if they are also liable for deportation, and so on, or if they may be adversely affected. And then further information about contact. And then on the next page, 548, in the middle, if the responses suggest that there will be a family separation or the child's welfare could be at risk, and clearly on the evidence we say, clearly there was going to be a family separation if Mr. Byndloss is to be deported, you will need to consider referral to the Home Office's Office of the Children's Champion. There's no evidence that that consideration was given. So they have the systems in place, almost like window dressing, but they don't actually follow them, which is Mr. Justice McCluskey's complaint in the cases that I referred to. And then it goes on at page 552, MS 552, internal page 15 of 32, assessing impact of deportation or detention on children. In the middle, it says, although every family situation is different, there are some principles which can be applied to most detention and deportation cases. When you have a complex case, and this was a complex case with 3 family units being operated very successfully, as it happens, or when you feel a more in-depth consideration is required, you can seek advice from a senior caseworker. That puts it in permissive terms. And then at page 554, at the bottom, separation effect, it notes that there can be a long-term separation, that there can be an effect on children of separation. So that's fine. On page 556, it notes the need to take into account the child's views, possibly by contacting other professionals, none of which was done in this case. And then it recognizes at the bottom of page 556 what contributions means. It says the loss of contributions to family circumstances made by the adults being considered for deportation can have an impact on children. Contributions can be emotional, financial, or care-related. In large families, it can be difficult for the remaining parent to cope, which is what the ladies are saying. And
I mean, this all goes back to the point that they were saying there wasn't any meaningful relationship. You say, well, there clearly was some sort of relationship, and that brings you on to all these points which say they failed to consider.
Before they could
One
even
doesn't need to go through all these points.
Before they could even
Major.
consider that, before they could even conclude that, they needed to go
Yes,
through
no, I
this.
understand that.
And then,
Can I just ask you something, because we're running out of time? The Court of Appeal recorded, they took the view that things were sort of stopped at September, the letter of September 2015, and all the other material, including the ISW report, was really not directly in point. But they also record Lord Keane saying, well, we'll be considering all this with a view to seeing whether any of it affects our position.
they haven't done.
Well, that's what I wanted to know, because, and we'll hear from Lord Keane, but I mean, the ISW report on its face is a serious independent report, which does make quite a strong case for a relationship. But I just wonder whether there's any evidence of that having been considered.
We've made the point in our printed case. Even now, the Secretary of State hasn't done, and one assumes, therefore, that they are wanting to maintain that certification.
Right, thank you.
But I'm sorry, my lord, but I think I do have to go through this at 558.
No, I just want to get that point in before 4 o'clock.
I'm grateful.
Thank you.
It says when to contact the Office of the Children's Champion. And you see in the left-hand column, there are boxes on page 558, complex issues, so family members, especially children, a Tier 2 trained senior caseworker. No evidence as to who the caseworker was in 6th of October 2014. I don't know whether Mr. Welsh, who made this 3rd of September 2015 decision, is trained in this regard. Complex issues. The senior caseworker must seek advice from the Safeguarding Children's Code. Not done. If any of the following apply, separating a family that involves child or children using the OCC referral form, the Safeguarding Children's Coordinator will provide advice, etc., etc. None of that was done. And then they go on to say, I think, at the end about training, that they are on page 565 at the bottom, as new procedures relating to managing family returns without the use of detention settle in, appropriate training courses are being developed. So it doesn't appear as if anybody had been on a training course, even at this point, because they hadn't got the training courses in place. And even now, there's no evidence about this. There is if I can perhaps leave those points there, because I want to say something about the guidance in, unfortunately, rather limited time. Now, the way in which I propose to approach the issues in relation to the guidance is this. Version 1 of the guidance, and in fact, version 4, in fact, all previous versions, and I'll deal with the current one separately, we say are unlawful because they fail to apply a child-sensitive approach for the reasons that are set out in our printed case. They, at least up to version 4, which was the version in existence just before the Supreme Court hearing, they were unlawful for the reasons the Court of Appeal said. But they were also unlawful because they actually completely failed to have regard to children's interests properly. Quite sure where they are. Just for your note, version 1 is in Appendix 4, page 1050, MS 7916. Version 2 is same volume, MS 7924. Version 4 is in 7934. But essentially, and one can take it this point on version 4 just from MS 7938. They say at the bottom of that page, 3.6, by way of example, the following scenarios where a person is deported before their appeal is determined, it is unlikely in the absence of additional factors that there would be a real risk of serious irreversible harm when an out-of-country appeal is pursued. And you will see there the very high thresholds that are being set out. So the mere fact that a person is going to be separated from their child or partner for several months, or there's a family court in progress, see Chili's, for instance, none of these sort of considerations appear to be, or even when a child is undergoing temporary or chronic medical condition, but the other parent can look after the child. None of these things apparently are going to be sufficient. Now, since then, there has been slight revamping of the language in version 7, which is the version in Authorities Volume 2, which is here at tab 26, MS 446. And this is the current version, which has been made with an eye on the changes that have been made in the legislation. But even here, I don't have time to go through all of it, but they set out, for instance, at the bottom of MS 460, internal page 15 of 32, examples: serious irreversible harm or breach of human rights. So they're still putting serious irreversible harm first, still directing the reader's attention to that sort of concept. And so the following are examples where certification may be appropriate in the absence of additional factors. And you just look at the sort of factors they're talking about. And it is difficult to see that those factors really place any adequate, show any adequate respect for children's interests. Look at the following examples after that, where in the absence of additional factors, removal pending appeal may give rise to a real risk of serious irreversible harm. But perhaps getting a little better than it was before. And then going back a bit, sorry to rush, but if at MS page 459, the internal page 14 of 32, you see how they still emphasize serious irreversible harm. And they say what serious and irreversible means for their purposes. And going back a bit further, sorry to do this backwards, internal page 11 of 32, MS page 456. Consideration of evidence, second paragraph. You are not required to undertake additional research or to make additional inquiries in the generality of cases. The courts have been clear, see, for example, SS Nigeria, that it is for the claimant to make their case and raise matters of relevance. That is not what SS Nigeria says. SS Nigeria is dealt with in our printed case, but when you look at it, although I have criticisms of that case, because I say that it is not a case which shows proper respect for children's rights, even there, the Court of Appeal didn't say this. What they said is that you can expect the parent to be providing the information. They are not excluding the possibility there that inquiries would have to be made by the Secretary of State. What the Court of Appeal, Lord Justice Laws and Lord Justice Mann were saying was, but a tribunal should not, it should be rare for a tribunal to have to go out on a limb and make the inquiries. That's understandable. That why should the tribunal be put in the position of having to go out searching for material and to be proactive? True, it has to be, it's a public authority, when really the burden should be on the Secretary of State in the first, the person concerned has to provide such information as they can, but the Secretary of State can't sit back. Therefore, for those reasons, we say, and for the reasons set out in our printed case, there was a very clear duty, and is a very clear duty upon the Secretary of State to adopt processes in line with what their documents, what that document that I showed you, tab 29, actually requires them to do, in line with the UN Convention on the Rights of the Child, Article 12, in line with with paragraphs 34 to 37 of ZH Tanzania, where a sort of inquiry process at an early stage was contemplated and recommended as a possible, as a useful way, in line with the approach they adopt in the family returns policy, process, which is dealt with in our printed case. So if they can do that, why don't they do it here? The reason is because there is a political end result that is desired to get people out as fast as possible, to make no inquiry, and in a children's case, this is simply unacceptable. The guidance, therefore, we say, is unlawful.
Well, that would appear to be an appropriate point. Which
The case of Karupan, which you referred to, seems to me potentially quite an important case. You've run out of time for saying how you apply it to the facts of this case. We'll have to think about that. Do we know, did the Court of Appeal set a date for the service of evidence when it gave directions for the hearing of the appeal, expedited hearing?
I don't believe so, but I'll check.
Thank you.
The rest is in the printed case.
the rest is in your,
Thank you very much.
the rest is in your extremely full printed case.
I've had a lot of assistance there.
I see you surrounded by assistants, yes, and we will understand that they have made a big contribution. We will now adjourn until tomorrow morning, when I imagine a certain rearrangement may be necessary, at least temporarily.